Welcome back to Talk Jamaica streaming live at Talk Jamaica Radio and also at Carib Rhythms Radio. My name is Ricardo Brooks and my co-host this afternoon is Ralston Chamberlain. Now, listeners, you heard in the week that was that prominent attorney at law and gay rights activist Maurice Tomlinson is mounting a challenge to the country's laws that address buggery.
According to Tomlinson, the argument is not just that the Offences Against the Person Act criminalizes gross indecency between men and the abominable crime of buggery, but more importantly, listeners, recent legal developments mandate registration, monitoring, and potential additional penalties of the sex offender. His lawyer Anika Gray said that not only is the law an infringement of the human rights, but it drives gay men and other men who have sex with men underground away from desperately needed HIV prevention treatment and testing services.
Our producers invited the representatives of the Christian group's cause and the Lawyers Christian Fellowship. However, they indicated that they will not comment on the lawsuit at this time. One representative, Helene Colin Nicholson, with whom our producer spoke, said they have noted the development and that they will respond at the appropriate time. We have joining us at this time Maurice Tomlinson and his attorney, Anika Gray. Good afternoon, gentlemen. Welcome.
Thank you.
All right, Mr. Tomlinson, let me start with you and ask you, why no?
The sad reality is that the government is not in any hurry to repeal this law, despite the Prime Minister's promise in 2011 to even do a review. And it is unlikely that in the current climate, where the level of homophobia is registered at nearly 91%, we're going to see any political movement on this repeal. We'd much have preferred if this law was struck down by Parliament, but since this is not going to happen in the end, and since people's rights are being infringed, including my own, and the HIV epidemic is raging among MSM and going down among everybody else, we feel that it was the only appropriate to the courts to get justice.
Mm-hmm, mm-hmm. You cited the fact that, upwards of 90% of the Jamaican population is polled as being, homophobic and against this repeal. Do you think at all that those numbers will affect the judgment of the court?
I do not think so, because the court is designed to protect the rights of minorities when it interprets the charter. So the court, this is designed. The court is expected to look at the constitutional provisions, the rights therein, and how they affect me as an individual, not how the general population views my rights. Because if that was the case, then minorities would never have any protections under a constitution, which is a very important thing.
Mm-hmm. Ms. Gray, the points of law. I was reading through the documents filed. You make several claims in terms of how you think the anti-sodomy laws breaches the charter. Could you take our listeners through those claims and then explain the complications arising from the savings clause?
Okay, so the basic claim that the basic argument King is making is that Section 76, 77, and 79 of the Offences Against the Persons Act criminalize private consensual acts of intimacy between gay men. And by doing so, they infringe Maurice's rights as protected by the 2011 Charter of Fundamental Rights and Freedoms. Mm-hmm. And for most of your listeners, they probably do not know what exactly 76, 77, and 79 stipulate. So I'll just give you a quick summary. So first, Section 76 prohibits intercourse. And upon conviction, can face up to 10 years in prison. Second, Section 27 says that anyone who's caught attempting or trying to have intercourse can face up to 7 years in prison. And third, Section 29 says a crime called gross indecency, and it is directed solely at preventing men from engaging in certain acts of intimacy with other men. For example, a man who's caught kissing another man is liable to be convicted and sentenced up to a minimum of 3 years in prison. And the scope of these three sections is extremely broad. So they apply regardless of whether or not the persons involved are in public or they're in private. They apply whatever the age or relationship of the participants. and most fundamentally, they apply whether or not the parties are consenting to the particular act in question. And so we are arguing that these provisions, which Maurice's right to privacy, right to equality before the law, his right to freedom of expression, his right to be free from cruel, inhuman, and degrading treatment, and his right to liberty and security, and these are all rights which are protected by the 2011 Charter. The second thing that you mentioned is in relation to the savings provision within the Charter. And this provision in the Charter says that all sexual offenses which existed before the passing of the Charter, or that existed before the Charter became law, cannot be challenged on the basis of being unconstitutional. And what we are saying is that even though Section 26, 27, and 79 were passed in 1864, and that was way before the Charter came into being, that particular savings provision does not apply to these sections because Section 26, 29, and 27 were changed or modified by the Sexual Offences Act, which became law after the Charter took effect as legally binding. Now, the changes that the new provisions of the sexual offences, what they did was to change the legal consequences of being convicted under 26, 27, and 29. And those new legal consequences are this. First, persons who are convicted under those specific provisions will have to be registered as sex offenders. And not only will you have to be registered as a sex offender, you have to carry a pass, and you face having to pay a fine of up to $1 million or being imprisoned if you do not have those passes. Mm-hmm. And you do not have that particular pass. And so what we're saying is that this modification has now opened up or has now made it possible for us to bring a constitutional challenge to those two sections.
Mm-hmm. And is it that there is some precedent that sets down that once the original law has been modified, then the savings clause ceases to have effect?
Yes, there absolutely there is. There's a case that was decided in 2004, a UK Privy Council case from Jamaica called Lambert-Watson, and that case dealt with the mandatory death penalty at that time. And what the Privy Council said is that once an existing law has been changed or modified in any way, it is no longer protected by the savings provision. And so anyone can now bring a claim to say that that particular law is unconstitutional.
I see. Mr. Tomlinson, are you prepared to take this all the way to the UK-based Privy Council?
Definitely. I think the point of my bringing this case is because I can safely do so since I have residence in Canada, so I can move freely. And my family have been so exposed to these kinds of issues already since I'm already in two cases that it makes it relatively easy for me to do this versus someone else in Jamaica or who is outside of Jamaica but has family here who might be fearful of the backlash. But I can guarantee you that in the same way I went all the way to the Caribbean Court of Justice with my immigration challenge to the laws of Belize and Trinidad and the Antwerp case, and I'm now before the Court of Appeal of Jamaica for the case where the TV stations refused to air my tolerance ad. I will take this case to the conclusion because this is not just an academic exercise for me. I want to return to a safe Jamaica where I can live without harassment with my partner. And it is clear that the government of Jamaica is in no hurry to give me justice, so I must seek justice for myself and my, other nationals who are LGBTI.
Mm-hmm.
Yes.
Let me ask you,
go ahead,
Mr. Tomlinson, because the government had indicated that they, would have bring the matter before Parliament for a conscience vote. Have you been in dialogue, yes, with the government or anyone in the opposition to get their feedback as to whether or not this would have been done?
Yes, and what we were advised is that because the numbers are so bad, quote unquote, in terms of the popular support for the anti-sodomy law, it would not be realistic to expect the government to bring this. Now, they're just not going to sacrifice LGBTI human rights, or sacrifice their political capital for LGBTI human rights. They have other things on their agenda. And, privately I was also told that this will help them because if the courts strike it down, then they can say, well, we didn't want to do it, but the courts have forced us, so, it takes the heat off the politicians, which is how this law was struck down in many other countries across the world.
Mr. Tomlinson, one of the arguments we hear coming from what I'll call the conservative right is that, listen, this is absolutely not the way to go about this. They've criticized, for example, that landmark ruling in the United States saying that this kind of social change should not be spearheaded by the judiciary, but rather through the parliament, through the legislative process. How do you respond to that?
Well, for the same reason that Nazi Germany failed to protect the rights of minority Jews, this is the same reason why we have a constitution. Because if we leave it up to popular will, minorities will always be disenfranchised and, effectively marginalized and in some cases killed because the majority benefit from this marginalization. So social change sometimes has to be done through parliament, and in many cases, thankfully we have constitutions that protect the rights of minorities. In many cases, social change has to be initiated by judicial action, where in a court of law, where reason, instead of emotion, reason and evidence can take sway. Persons can be confronted with the evidence and can then make rational decisions instead of these emotional responses that very eloquent and erudite, but definitely ideologically driven individuals, and I won't name any on this program because you couldn't get ready to come on, will raise. So that is why you need to have judicial challenge in some cases, because that's when you have the rational arguments coming out instead of the emotional arguments. The emotional arguments will make it almost impossible to get justice for minority groups.
Ms. Gray, as the attorney, do you have any safety concerns about bringing this case on behalf of Mr. Tomlinson?
Can you repeat that question? I didn't get it.
Yes, I'm asking, are you in any way afraid for your life or, security of your person because you are the attorney representing Mr. Tomlinson?
Well, at present, I would hope that I am not in any kind of danger. So that's all I can say for now, that I would hope I'm not in any kind of danger.
All right. Mr. Tomlinson, you mentioned the matter before the Caribbean Court of Justice. As I understand it, the court reserved judgment in the matter. Could you explain to our listeners what's at stake in that case and what it means when the court has reserved judgment?
We are challenging the laws of Belize and Trinidad and Tobago, which ban the entry of homosexuals and other marginalized groups, such as the disabled and the persons who they describe as mentally and physically defective. It's really a horrendous law. And we were saying that this law violates the right to freedom of movement under the Revised Treaty of Chaguaramas, or the CARICOM Treaty, for all persons within CARICOM which have the right to freely move, whether they are, whatever class they fall into. Now, the Caribbean Court of Justice is the only court that can resolve this matter because it is concerning the Treaty of Chaguaramas, which concerns, as I said, free movement and other matters. The court heard the matter earlier this year. I believe we're going on to 6 months now, and they reserved judgment, which means that they didn't render judgment immediately. So they've gone to write the judgment, and I suspect they will be reviewing issues of international law, treaty law, enforcement, and the government of Belize and Trinidad said they have no intention of enforcing the law, so therefore it's not operative, which of course is nonsense because at any point they can enforce it. So all these matters the court um, is deliberating on, and they hopefully will render their decision soon, because I really would like to go to Trinidad for Carnival.
But let me ask you this, Maurice Tomlinson, attorney at law. What do you make of the argument then being put forward by persons that in filling out the immigration form, it does not specifically ask you whether or not you are gay, straight, or bisexual? And so there is no kind of an indication of them knowing that to prevent you from entering either Trinidad and Tobago or Belize.
The challenge with that argument is that it presumes that because you don't fill out a form, that there's no way for them to suspect or to eventually determine that you are gay and then deport you. At any point, the government of Trinidad and Tobago, once they determine that you are not a national and you are LGBTI, you are homosexual, you can be put on a plane and be deported. Neighbor, you could go to a hotel, you could, whatever context you're in, someone in Trinidad could determine that, you're gay, we're going to send you back. And then in my case, because I'm a well-known LGBTI human rights activist, you can imagine if I go to an immigration officer in Trinidad, they wouldn't have to guess if I'm gay. They know that I am. I've been doing this work across the region for some time. When Elton John tried to visit Tobago to do a jazz concert, they had to give him a special pass because all the churches were up in arms and said if he came, all the people who were confused about their homosexuality would become gay if they heard him. So people who are able to fly under the radar to get in may be caught once they're there and be deported. And then persons like myself who are well known may also be deported on arrival.
Mm-hmm. And then I want to come back, Maurice, if I will, to the issue of your own safety, because you did indicate that you live in Canada and so you think it's apt for you to have brought this case. But if we recall, Mr. Jagai was living in America when he brought this case, and one of the arguments put forward for having abandoned the case was that it was a fear of safety for himself, having had to go back there, and also fear for his family. Does any of this factor into your file in this case?
I mean, the reality is that there's always going to be some danger associated with these kinds of controversial cases. However, I do have a security protocol covering my movement back and forth from Jamaica, and my family is as safe as we can make them. We have taken certain precautions to make them as safe as we can because I am already involved in two very controversial cases, and I was Javed's lawyer. So, there's no 100% guarantee of anything, but we've taken the best precautions we can, and I certainly also believe that at some point you have to be brave enough to stand up for what you believe in, and this is what I'm doing.
Mm-hmm. And let me just ask Maurice, if I could, is this case being supported, yes, by the local LGBT human rights group in Jamaica? Because you can correct me if I'm wrong. I think the Javed Jagai case was supported by J-Flag. Is this case being supported by them?
At this point, J-Flag has not decided to become a co-claimant or an interested party. That may change. QCJ, Quality Citizenship on Jamaica, that is a group that represents lesbian, bisexual women in Jamaica. The first and only so far registered group that does that. They have vocalized their support, and other individuals have. So, persons are taking a wait-and-see approach, I suspect. But again, this is a case that I am bringing for my own sense of safety. I have property in Jamaica and I need to return here and be safe when I'm here. And I need to have the government supporting me and protecting me. And I would hope that other groups and individuals would see this as a worthwhile cause to join. But I am not prepared to wait on them to do that before I proceed to assert my rights.
Right. Ms. Gray, what are the next steps? So it's been filed in the Supreme Court. What happens next and when does that happen?
Okay, so the first hearing for the case will be next year, February 23rd, and that will be some sort of a case management hearing. It's a preliminary hearing, so it won't be the we won't be arguing the substantive matters. So that will be February 23rd of next year.
Do you expect that it will go through the court process in a fairly, expedited manner, or should we expect a protracted legal battle?
Well, there are two things. First, the court, since it is a constitutional matter, the courts usually try to ensure that constitutional matters are dealt with pretty swiftly and pretty quickly. So that's the first thing. The second thing, though, is that we might have a lot of groups wanting to be joined as interested parties. And with having those persons be joined as interested parties, we might find that there will be several applications which might hold up the case, and therefore the hearing of a substantive matter could take a little bit longer than usual. So those two factors will determine how long it takes.
So at the end of this, just so we're clear, you want the court to declare the law null and void, unconstitutional. What exactly?
So there are two main orders that we're asking the court for. The first, we want an order and a declaration saying that insofar as Section 26 and 27 criminalize private consensual acts of intimacy between women, they are unconstitutional, and the provision should therefore exclude private consensual acts of intimacy, but continue to govern non-consensual intercourse. And the reason we're asking for that particular order is that we recognize that currently there is no provision in the law which takes into account persons who might be raped anally. And so if you take away 76 and 79 completely, there will be a lacuna in the law. The second provision that we're asking, the second order that we're asking for is that Section 29 should be declared unconstitutional in its entirety and taken off the books completely. So those are the two main orders.
Let me ask you this, Miss Gray, because one of our listeners is has posted in our discussion, and he said he wants to he's very interested in seeing how the argument that the Sexual Offences Act changes the relevant sections of the Offences Against a Persons Act, and he was making reference to the savings clause of which you spoke of. Could you shed some more light on that for us?
Okay, so as I explained before, Lambert Watson says that an existing law and 26, 79 and 27 would be considered an existing law because they were brought into force in 1864, which was before the Charter. So there's a provision in the current Charter which says any laws, any sexual offences that existed before the passing of the Charter cannot be challenged as being unconstitutional. That's what Section 1312 of the current Charter says. Mm-hmm. What we are saying is that 26, 29, and 27 can no longer fall under that particular provision because they were modified and changed by the current Sexual Offences Act, which came into force after the passing of the Charter. We are saying that the Sexual Offences Act changed the legal obligation or the legal consequences of being convicted under 26, 27, and 29. And it changed the legal consequences in this way. Persons who are convicted under those three provisions will now, by reason of the Sexual Offences Act, have to be registered as a sexual offender. They will have to carry a pass. If they do not have that pass, they will have to pay a fine of up to $1 million, or they can be imprisoned. And those changes, those provisions of the Sexual Offences Act change, as I said before, the legal obligations of being convicted under 26, 27, and 79. And relying on what was held in Lambert Watson says that if an existing law has been changed or modified in any way, it cannot the savings law clause provision will not apply to it. And so that in a nutshell, that is the argument that we're making.
If I can make a quick point, the best
Sure.
way to explain it for, I think, your the listeners, to simplify it, if the law had remained exactly the same, even if they took it out of the OAPA, Offense Against a Person Act, and plunked it into the Sexual Offences Act and did nothing more, right? Sometimes they do that. They take one law out of an old piece of legislation and plunk it into a new piece of legislation and do nothing more to it. But by taking it out, and they specifically referenced it in the Sexual Offences Act, Section 76, 77, and 79, are considered specified offences, and these specified offences now attract these new, as Ms. Gray said, legal consequences. You have added to it, and that's what number one says. If you have modified it in any way, you've added to it. So think about it. If you have a car and you put a luggage rack on top of the car, it's not the same car as before. It's been modified. And that's what we're arguing. It is a bit of an extension of the reasoning in Lambert Watson, but that is how law develops.
Yes. All right, Mr. Tomlinson, Miss Gray, we'll be watching this case carefully, and we certainly wish you all the best in your challenge. Thank you for joining us.
Bye-bye.
Okay, thank you.
All right, bye-bye. Listeners, you were hearing there from attorney at law Maurice Tomlinson and his attorney Anika Gray. They are challenging Jamaica's anti-sodomy laws in the Supreme Court. Mr. Tomlinson saying he is prepared to take the matter all the way to the Judicial Committee of the Privy Council. And you'll remember, Ralston listeners, that Mark Golding issued a very interesting, I'll say, warning. He said, be careful, those of you who favor the buggery law. If you don't sign up for the CCJ, you might just find that it is the Privy Council who nullifies that law. Could Senator Golding's comments have been prophetic? We'll have to wait a couple of years to see. We'll certainly, as I said, be watching this case very carefully.
Indeed, Ricardo. It's one to watch, and having seen that someone had taken up this case prior to now, I'd be interested, yes, and I'm sure those lawyers out there in the legal world will be interested to see the ruling on this one.
Absolutely.